Namaste. Telugu Prajala Mana Sakshi TV. I am Swarna. Welcome to Sakshi TV special immigration show with attorney Mr. Chandra Parvathaneni. He is currently a founding partner and managing attorney at the law firm of Sim, Parvathaneni and Brown, PLLC based in Dallas, Texas. If you are an immigration attorney and would like to join us in our special show, please email us at usa@sakshi.com or call us at 866-725-7441. Before we begin the show, please note down that the information provided in this show is not a legal advice. It's for general information purposes only. Sakshi TV or its agents are not responsible for the use of this information. If you need to specifically legally advise us, please contact attorney directly. Without any further delay, let's start our show by welcoming Mr. Chand. Hi, Mr. Chand. Welcome to our show.
Hello, Swarna. Good afternoon.
Good afternoon. How are you doing today?
Pretty good. Thank you for inviting. And it's a great day in Dallas today.
So, can you please update us on the latest immigration updates and any noteworthy changes in the recent weeks?
Sure. Firstly, thank you to all the viewers of Sakshi for joining today. And so lately, we've been having a lot of positive news on the immigration side in US. And the new administration has been taking a lot of measures to simplify the immigration process and to make the immigration process a lot more smoother. And with that being said, a couple of changes have happened in the last 1-2 weeks and a couple of updates. So USCIS recently rescinded a 2018 memo that talks about request for evidences. As you all know, the RFEs or the request for evidences are very dreaded. Anytime anybody applies for an I-140 or a H-1B petition, the RFE has become a very common thing in the past. And anytime anybody gets an RFE, people get worried. So in 2018, there was a Trump-era memo that said that USCIS does not even have to issue an RFE. They could directly deny the case. That was a big change from the past because previously always an RFE was required. So people were given a chance to rectify any mistakes in their petitions. And with the 2018 Trump memo, USCIS officers can directly deny a case. And that caused a lot of stress on the immigrants, the petitioners, the attorneys. And we had to be very, very careful with every petition because the case can now be directly be denied without giving any chance of a second chance of correcting any issue in the petition. So last week, this memo was rescinded. What that means is USCIS cannot directly deny any case. They have to issue an RFE, and the petitioners or the immigrants, the applicants, they will be given a chance where they will be pointed out the deficiencies and they will be given a chance to correct any deficiencies in the applications or petitions. So that is very good news because now one does not have to worry about an accidental omission that will lead to a direct denial, because direct denials will not happen anymore. So that is one great news. And the second good news, positive news, is for a lot of the EAD applicants. So lately, we all know that EADs are taking a very long time to get an approval. They're taking as long as 1 year to get an approval. And people know that there is an expedited processing option. However, the option is not really a practical option because anytime the applicants have been trying to expedite their EAD requests, they get a denial of that request. USCIS currently has a policy. They have a policy where if some application is in the national interest or if not issuing the EAD card would lead to severe financial loss, they can be given expedited approvals. However, the problem is the regulations are not very clear, and what that means is the officers have too much discretion. So typically what we see is people keep on opening up expedited requests for EAD cards. They keep getting denied. The agency recently, in the last few days, they came back and said that they will issue some rules where the officers will have clear clarity on when a particular application can be approved. What that means for the community is that there will be a smooth process to expedite the applications. And what that means is if somebody really in need of an EAD card for a reason such as them losing a job, if not for the EAD card, there will be a better and a smoother approach for expedited approvals, and that's coming very soon. USCIS also clarified that going forwards, to smoothen up the EAD process, the approvals for some categories will be given for 2 years and not for 1 year anymore. And this would help a lot of the I-485 applicants who are used to seeing approvals for 1 year. And every year they have to go back and reapply for the EAD card. So the agency confirmed that they will be issuing long-term, at least 2 year EAD cards. And that is definitely good news, not only for the applicants, but also from a USCIS perspective, because it will release their resources, which means things can get faster on the other side. And the last update I have is regarding deference to the previous approvals. And again, during the Trump administration, there was a USCIS memo that said that any of the previous approvals, the deference will not be given to those approvals. What that meant was somebody on H-1B could have gotten an approval in the past, but when they apply for their extension, that extension could be denied because the policy was that the officers do not have to give any kind of deference to the previous approval. So in the last month, that has changed. So the new administration rescinded that rule. And now the rule is that somebody applying for an extension, the USCIS officer has to look at their previous approval and give deference to that previous approval. So that is also great news for Indian nationals, because one doesn't have to worry about applying for an extension and getting a denial in that process, because now the officers have to give deference to the previous approvals. So overall, I think it is positive news for the community. And the only negative news is the unfortunate COVID pandemic in India. And that has resulted in a travel ban for the H-1B visa holders or for the B-1, B-2 category. So anybody in India who wants to fly to US on H-1B visa or B-1, B-2, right now they have a ban unless they're exempt because of some conditions. And I mean, that is unfortunately, the travel ban is still in effect. And hopefully that ban will be reversed very soon. And those are the updates I have on the immigration front.
Okay. So we are hearing news of major increase in number of green card issued to Indians this year. Can you please elaborate about that?
Sure. So every year, US, United States can give only 140,000 green cards in employment-based category. Out of the 140,000 green cards that US gives every year, Indian nationals, people who are born in India, can only be eligible for 7% of the 140,000 green cards. So what that means is in any given year, anybody who's born in India, only 10,000 Indian nationals can be given green cards. So overall, if you look at things, that is very, very less number. So you're only looking at about 10,000 green cards a year to Indians, either in EB1 category, EB2 category, or EB3 category, in all three combined categories. However, last month, Mr. Charlie Oppenheim, the official in charge at the Department of State, so he's the one that runs the numbers on how many number of green cards can be given, any additional green cards based on any spillover from other categories. So he confirmed that about 290,000 green cards will be issued in the next fiscal year, that will start in October 2021. So what that means is that to the usual 140,000, this year we will be seeing about 150,000 additional green cards that will be issued to the employment-based categories. And we previously said that Indians can qualify only for 7% of 140,000. But for the additional green cards, the 150,000 additional green cards, there is no 7% quota. So what that means is that 150,000 additional green cards will go in the order of the priority date. So whoever applied the earliest, they're eligible. So what that means is since India, along with China, are the only countries that have a very, very huge backlog, and compared to China, India is the one that is very badly retrogressed. Our expectation is that about 80 to 90% of this additional 150,000 green cards will go to Indian nationals. So what that means is, any given year, you're typically looking at about 10,000 employment-based green cards to Indian nationals, versus this year you're looking at about 10,000 out of the 140,000 regular green cards. Plus, because of the spillover, we are looking at least 80 to 90% of the additional 150,000 green cards in the next fiscal year. So what that means is, a lot of Indian nationals who have been working very hard in the country, paying taxes for a very, very long time, providing services in very high tech occupations, they are finally going to start seeing getting green cards after a very, very long wait. And this is really going to help the community. And this is also going to help the US as a whole, because when people become green card holders, they start investing more in the country, and it's going to help US, and it's definitely going to help the families who have been waiting for a green card for a very long time.
Okay. So what are the current priority dates? Like, what can we expect in this month bulletin?
So the current priority dates for EB1, it's current. So EB2 is currently in 2010 December, and EB3 is November 2011. And last week there was a meeting with Charlie Oppenheim. He had an open forum with immigration lawyers, and he gave some very good predictions for the July bulletin. So the July bulletin will be out in the next few days this month, and according to Mr. Charlie Oppenheim, the dates will move for EB2 and EB3. EB2 is expected to go to July 2011, and EB3 is expected to go to 2013 January. And the dates will be published in the next few days. And at least Mr. Charlie Oppenheim, he has confirmed that dates are moving ahead even this month. So it is again good news to Indian nationals, and anybody falling within those priority dates. I think it is time for some relief, and I think people should just be prepared for the dates keeping on getting. The dates are going to advance in the next couple of months, and people have to be ready for the advancement.
Okay. So what are the steps involved in filing for an employment-based green card? Is this like filing by employees, or can be done by employees' families? Or, can they do the filing themselves?
So getting the green card is a multi-step process. So the very, very initial step is the process where the employer starts the process by filing the labor application and then the I-140 petition. So the initial labor and I-140 are the ones that the employer handles it. So that is the employer basically notifying USCIS that they do want to sponsor somebody for a green card. And once the labor is filed, that is what is called the priority date. And typically the labor and I-140 is a 6 to 12-month process, which is done by the employer. And once that is done, in the last few years, Indian nationals are typically used to waiting for about 5 to 10 years before they go to the next phase, the final phase. So the final phase is where the employees are just looking at the visa bulletin and waiting for the dates to be current. So when it is like a time like this year, where the dates are rapidly progressing and a lot of the dates are getting current, at this stage, the employee is the one that should take the action. The employer is not involved primarily in the 485 process. So the 485 is the process, is the application where the employee files with USCIS, and that is the final step to get the green card. So anybody whose dates are getting current, they have to make sure they're ready to apply for the I-485, and they apply for the I-485 application with USCIS when the dates are current. And this I-485 application, it is a separate application for every family member. So if a family has a spouse and one child that is born in India, so they have to do 3 I-485s. So one I-485 application for the primary person who is working, and one for the spouse and one for the child. So it is 3 separate applications with 3 separate fees that are done to USCIS.
Okay. So what are the costs associated in filing for such like I-485 application for getting the green card?
So the I-485 application consists of a couple of applications. So it is the I-485 application, which is the application for getting the green card. And then simultaneously, one can also apply for the EAD card. So it is the employment authorization document application. One can also apply for a travel permit. So what the travel permit does is they can go out of the country and come back without a visa stamping. So typically, when somebody files a 485, they file the travel permit, the travel permit, and which is the advance parole. They file for the EAD card, and then they file for the 485. These three will go out simultaneously, and the fees for that is $1,225 typically if it is an adult. If it is for the child, it is $750. Apart from that, typically there are attorney fees associated, and generally our recommendation is that it is better for the employee to use the attorney that has done their I-140 or that represents their company, because that attorney already has access to their company documents, the I-140 documents, uh, because the I-485J, which is a document that is required to be signed by the company, that is also required to be a part of the package. So typically, it is always advantageous for the employees to work with the attorney of their employer. It is not required, but it is advantageous. And that being said, it is an application that is done by the employees.
Okay. So, what steps should Indians who are waiting in line for an employment based green card currently should take based on recent reports of numerous green card numbers that will be potentially available for Indian nations in upcoming fiscal year?
Right. So, so last year, October was when we started seeing the big jumps after a very, very long time. And during last October, when the dates became, I mean, the dates advanced very rapidly all of a sudden, it a lot of people were not prepared for that, and a lot of people's I-485s were delayed. And what that meant is a lot of people applied before them, and now because they applied a little bit late in that month, they are seeing delays with their EAD cards and advance paroles. So to avoid that issue, people should be prepared with all the documents even before the dates get current, because the document list is very simple, and it is simple, but sometimes it could take time, especially because of the pandemic, and especially because sometimes you have to go get those documents from India, from the local authorities in India. So, what are those documents? So, the main document that is required for the I-485 filing is the birth certificate. So, a copy of that birth certificate is required. And there are rules on what kind of birth certificates are accepted for each country. And from an India perspective, typically, if the birth certificate is registered within 1 year, typically it is always accepted. And it is very common for Indian nationals not to have birth certificates. And I mean, it happens a lot. But again, the birth certificate is a mandatory document, and people should try to get their birth certificate in order. And the second thing is, especially for the people who are married and who are dependents, the marriage certificate is required. So these two documents are required. So people should ensure that they get in touch with the authorities in India or their family in India in case the documents are in India. Make sure they have access to it, they have copies of it. So by the time the dates are current, they're not running for the missing birth certificates or missing marriage certificates.
Okay, so what can one should do, like if they lose birth certificate or marriage certificate, if it is missing, then how should they manage?
Sure. So if somebody is missing the birth certificate, typically in India, it is issued by the local authorities. So they should contact the local authorities, either the municipality or depending on the state, the local authorities in the state for the birth certificate. And for the people who are able to get the birth certificate, I think they should not have any issue. But again, there is always possibility that people don't have that birth certificate. It is not available at all. And in India, there is something called Form 10. It is a form basically that says the birth certificate is not available. It's Form 10, notice of non-availability of birth certificate. And this is typically issued by the local authorities. Typically it's an easy process, but because of the COVID pandemic and because of things being slow in India because of the pandemic, it could take some time, but there's a process. So people, I think, just have to get in touch with their family members in India, ask them to start getting that process started to get the Form 10. So Form 10 is something that says their birth certificate is not available. So once they get that Form 10 saying that birth certificate is not available, they can get some affidavits. So typically for anybody that does not have the birth certificate, two affidavits are required. And anybody that was present at the time of the birth, maybe their father or their uncles, aunts, their family members, anybody who was present at the time of birth, they can issue that affidavit. So it's a simple affidavit saying, yes, we are aware of the birth, so and so was born on so and so date, get it notarized, a simple affidavit. So two affidavits from two individuals who are aware of the birth is enough. So the Form 10, which is the non-availability of the birth certificate, along with two affidavits, is all that is required, and that will be accepted by USCIS. And again, it takes time to get those affidavits. So if somebody knows that they do not have those birth certificates, get started right now and keep them handy. The same thing with marriage certificate. Again, the good thing about marriage certificate is even if it is late, it is easy to get marriage certificate in India. However, it could take time, so better to get started right away. And in case somebody is not able to get a marriage certificate, the affidavits are enough. So again, two people who are aware of the marriage can give affidavits, and the affidavits will be accepted by USCIS.
Okay. So our credit reports, assets, liabilities information, educational certification, etc., like required for the green card filing, will bad credit history impact the green card process?
Yeah, so a lot of people get concerned when they have bad credit history or probably a bankruptcy on the record in US, uh, or their spouse does not have proper education, they don't have educational documents. They get concerned. The reason for the concern is because during the previous administration, there was something called I-944 form that was required. So, as a part of filing for the green card, one had to disclose their assets, liabilities, the credit score, and a whole bunch of other information, even their educational documents and other information as a part of the I-485 filing. People were concerned. But again, the rules have changed this year. So this year, the I-944 is not required. It is not required to be a part of the I-485 filing. So what that means is the credit score does not have to be reported, and the assets and liabilities, they do not need to be reported as a part of the I-485 filing. So what that means is bad credit score will not impact. The educational documents do not have to be produced for the 485 filing anymore this year. So they should not cause any issues for the I-485 filing.
Okay. So how do traffic violations and any minor criminal issues impact the green card process? Like, do traffic violations and any minor criminal infractions need to be disclosed in the green card I-485 applications?
So as a part of the I-485 filing, there is a question that says, have you ever been cited or arrested? So any arrests have to be disclosed in full. And it is very important that they're not only disclosed, but the original police certificates and even the court, any court orders, if any, have to be produced as a part of the I-485 filing. And these have to be in original. Apart from the criminal records, the traffic violations, a lot of people have this question. They just got a traffic ticket. They were not arrested. Do they have to report it? So the general rule is it comes as a citation. A traffic ticket is a citation. So anytime anybody has been cited, even for a small thing, one has to disclose it. It will not, the traffic tickets will not cause them any issue. These are all, I'm talking about the minor traffic infractions. They, in terms of any impact, they don't have any impact, but they do have to be disclosed. So that way USCIS has that information. The criminal violations are the ones that one has to be concerned about. And definitely, if anybody has any criminal violations, they definitely would have to talk to their attorney.
Okay. So once the I-485 application is filed, can one work for any employer or travel out of the country without requiring a visa?
Right. So a part of the 485 filing is the applicant showing a bona fide intent to work for the company that is sponsoring for the green card. So the the employment based green card, the way it works is there is an employer who sponsors for the green card. The employer files an I-140, and the foreign national accepts that offer. And because the foreign national wants to work for that employer, he applies through I-485. And as a part of I-485, the I-485J is also required to be submitted. And the I-485J says that the employee is accepting the job being sponsored by the company. So what that means is, on the day of filing, one definitely needs to have a bona fide intent that they do intend to work for that company. However, US it's the US as a country. It encourages talent. It encourages people to have flexibility, and it encourages. I mean, it does not encourage the companies to lock somebody down for a long time. So what that means is, in terms of the rules, there is a 180-day rule. So what that 180-day rule says is that when the I-485 is filed, there is a 180-day rule. So after 180 days, a foreign national can put to a different employer. So after 180 days, even if the employee goes to another employer, there is something called AC-21 portability, and the employee will not have any issue. But before 180 days, if the employee leaves the employer, they could run into issues down the line. So this is something called AC-21 provisions. And based on the AC-21 provisions, after 180 days, after the 485 is filed, one is free to work for any employer. But there are some conditions. And the conditions are that when the foreign national is applying for a job, is applying for the green card. So their green card is based on an underlying labor and underlying I-140. And as long as the foreign national takes up a job in the same or similar occupation, they are free to change their employer after 180 days. And that is something what one has to be concerned, and one has to be very careful in accepting new jobs, because an analysis needs to be done to make sure that the new job is in the same or similar lines, and based on that, the employee should not have any issues. So that's on the transfer to different companies. And regarding travel, so regarding travel, one cannot travel out of the country right after the 485 application is filed. They have to wait until their advance parole is approved. And once their advance parole is approved, they can travel out of the country and travel back into the country without any visa. And if anybody wants to travel out of the country before getting advance parole, they definitely need to talk to their attorney for suggestions, because there are exceptions. In general, one should not travel once I-485 is filed, but there are exceptions, and their attorney should be able to let them know if they're good to travel, or the risks associated with such travel.
Okay. Before we discuss more, we have a caller, Mr. Krishnan.
Sure.
Yes. Hello, sir. Good afternoon.
Hey.
My name is Krishna.
Hi.
Good afternoon, sir. My name is Krishna. I have a quick question about my porting my I-140 approval. Actually, my I-140 is approval on EB2 category. But I have a PhD in India with the NGS technologies. So could you please help me on that? How to can we port or upgrade my I-140 from EB2 to EB1 category?
Sure.
Yeah. And one more question, sir. When I see your website and I Google, there is any evaluation contact with you personally. Is there any facility?
Sure. So first thing about the porting. So you already have an EB2, and what that means is, when you do the porting from EB2 to EB1, if your EB1 I-140 gets an approval, you will get the old EB2 priority date. So even if you file for EB1 right now and it gets an approval, you will be able to reuse your EB2's priority date. And that being said, EB1, because you have a PhD, you more than likely could qualify. You probably are a good candidate for EB1. And EB1 has two categories, EB1A and EB1B. So I think definitely, I think EB1, it's a complex petition. Work with an attorney and do the analysis. And based on that, I think you should definitely look at the I-140 filing, because for some I-140 filings, you would be able to directly do it by yourself. For some, you might need a university to sponsor you. So, and based on that, if your I-140 goes through under EB1A or EB1B category, you will get the old priority date. and definitely you would need some evaluations, and also your research articles, and also your um, I mean, what kind of research articles you have published, and the site. I mean, how many other research articles cited your articles? So there is like a big analysis that you would have to do based on your research, based on your research articles, and present that evidence to USCIS. And hopefully, USCIS approves your I-140 under EB1. And the good thing from your perspective is that the day the I-140 gets approved, you will get the old priority date. And not only that, EB1 is current, and what that means is you will immediately qualify to apply for I-485.
Yeah. So thank you so much, Mr. Chand Parvathaneni, for clarifying all the questions. This is Swarna signing off. You're watching Prajala Manasakshi Sakshi TV. Namaste.
Thank you.